Welcome to Plato's Cave. I'm Jordan Myers, and I'm a master's student in philosophy at the University of Houston. You're listening to a reading group episode of the show, which means that in this episode I discuss political philosophy with two non-philosopher friends, Adam and Giffen, because philosophy shouldn't just be for philosophers. So, with that introduction, please enjoy our discussion of political philosophy. We're starting a new series on political theory, political philosophy. It's kind of open-ended. We don't have a game plan for it, but this is somewhat of a bridge paper between the moral responsibility stuff that we've been doing and the political theory that we're kind of moving into. So we're going to do a paper called "Conflicts as Property" by Nils Christie. It was published in the British Journal of Criminology in 1977. So it's a very old paper, but it started off, it kind of was the introduction point, or kind of the launching pad for a movement called restorative justice. And there was we watched two videos on restorative justice that I'll link to, as well as the paper in the description below. But kind of, because we haven't talked about this, what we think about the paper. First impressions before we get into it, because I have mixed feelings.
I would say I do as well. I like the concept in theory, but I don't agree with all the practices or implementation that she describes. Like, it's very rudimentary at the end, and she kind of acknowledges that fact.
Yeah,
I think it's a he.
It's a he. Nils is a he.
Obviously.
Okay.
No, I googled the name, and I'm pretty sure it's a male figure.
I think the last name Christie probably throws you off there.
Yeah,
maybe.
I guess so.
Let me just double check.
You know what's funny though is I actually found myself kind of like when I was thinking about, like, well, she doesn't do this. Like, I actually thought
it's a feminine philosophy,
in the feminine voice too. Yeah.
No,
I don't know. I guess the
Google
name,
images,
and I guess just kind of the writing style, kind of.
There was something. Yeah, it's like a very Susan Wolf writing style. I don't know. Well, no, actually, because Wolf is. I mean, there's no comparison to Wolf.
Well, I should have googled the author anyway. But
wait, Giffen, did you? So it confirmed Nils Christie is a man.
I don't want to make heavy assumptions, but Google Images would seem to agree.
Okay. Yeah. So, okay, Nils, I'm assuming, is a he. So with that important because like the truth of his work really hinges on that.
The pronouns are pretty critical here.
Yeah.
No, but I should have Googled Nils.
Yeah.
Okay, but I mean, either way here. Yeah, I mean, I liked the concept. I thought that I've actually never heard of this concept before. So it definitely added kind of like a new perspective to types of justice that can be implemented. So
I had only vaguely been familiar with restorative justice, but from what I had,
you had heard of it before this?
Very, very vaguely. Like,
okay.
It was a phrase that I would probably be able to nod at, but not much more than that. But I have heard it, maybe watched a YouTube video or something along that line, right? Like, no heavy interest for sure. But this, I mean, I think I mentioned it in the chat, but it kind of betrayed my expectations. I don't know. I would definitely have mixed feelings on this. Both the content and like the writing style. I have a lot of marks in places where I'm like, what on earth just happened in the preceding two sentences?
So,
but overall, it's definitely a thinker. It suggests. I thought it was kind of interesting because, well, we can get into it, the details, but just the way he presents it also is kind of like almost with, I don't want to say with shame, but with great hesitation. He hedges so many aspects of this. Like, he says, like, this is nothing more than like a framework. And several times he's like, I have not thought this far through. But, and like, I thought it was very odd, just the way, because it seems to be so foundational. And even from what we had, some of the supplementals you sent, like the cores there were kind of almost buried in this paper.
Well, to be fair, like
From my
I kind
perspective, at
of,
least.
I mean, it would be actually kind of weird, and I wonder if the paper would have been as popular had he actually given like a policy prescriptive. Because this is like, because I mean, both of you already pointed out, and you're right to do so, that this is like extremely rudimentary, and he's motioning towards grounds for the concept. But I don't know. I mean, the movement kind of like started off of this.
Of course, I'm not saying it's not worthwhile to publish this, but it's not what I expected based on like you having told me that this is kind of like the foundational work of that field, I guess.
True.
I think that was the expectation primarily, but also going through it, the turns that it made also kind of betrayed my expectations.
Okay.
So those are the two fronts.
And I do agree that like you would never expect like in a foundational paper for the author to like lay out and just hedge all,
and if you think this is an issue, then
exactly, and just address all concerns and lay out just some brilliant, thesis essentially of how everything can be addressed. Like I didn't expect that, of course, and it would be totally unfair to. But I think there are prescriptions. At the back of the paper that just kind of like, I love the concept, I think, but once...
See, I don't even know if I love the concept, to be honest.
I think I do. We can get into that.
So let me throw Giffen a bone, though, and admit that Giffen, if I were to anonymize this and submit it to a philosophy journal with this many citations and this loose of it probably wouldn't get accepted. So I don't think it could be published. It's a criminology journal, obviously,
right?
But that's also not to degrade criminology. That wasn't.
No. I understand. They might have different acceptances for like lower. I mean, it's really just a
lower. That was a jab.
I was going to say like lower. It has to be a jab, but it's like the lower kind of strictness with citations and like that you referenced, and also just kind of like the tone was different.
I just think that this was probably such a budding field and budding idea at the time that there probably wasn't a lot of ground already tread.
That's also true. Like, that must be the case. It's kind of just looking back, 50 years, and it's like you can see a little bit of like that age and the kind of expectations might have been a little bit different.
You could also get by with sloppy writing if your idea is like novel enough. I mean, it's like
that's true. It wasn't like. I mean, it sounds like he's like not necessarily. Oh yeah, go ahead. Sorry.
But like the point I want to make is this though. Like, I mean, I know that like if you listen to political philosophers speak of like Rawls, right?
Yeah.
They all complain that Rawls is an especially bad writer. Yet Rawls, kind of revolutionized the field like in the 20th century. So it's like I think if your idea is novel enough and interesting enough, the writing kind of takes like
you can drag it along.
It takes a backseat because the idea kind of is front and center. So
no, I mean that's totally acceptable, and I don't want to disparage like the work in just inherently. It was just it was mostly the difference between the expectations that I wanted to lay out.
If you think Rawls is bad, we'll just read like one passage from Kant at some point on the podcast. Sorry, Giff, what were you going to say?
I was going to say we can get into it, but I wanted to point out in the getting into it, one of the lines that kind of caught my attention as just striking. So this is just on the second page. Again, this isn't skipping any content or anything. We can go back, but it says, "My personal knowledge when it comes to British courts is limited indeed." And I'm like, what a crazy thing to just lay out.
Well, but you also have to. This was a Scandinavian writer in a Scandinavian journal. So
Norway, right?
No, it's in the British Journal.
Oslo.
The British Journal of Criminology.
So this is I think he's from Norway.
Oh, okay. So, okay, fair enough.
So it's within the British Journal of Criminology. He's like, I have very scant experience or knowledge, and I have vague childhood memories. I'm like, okay. It doesn't necessarily mean the ideas are flawed, but it's like, you didn't think to like do a little bit of like research, like wander into a court one day before you write this?
To defend Christie though on that, I don't think you would need that to lay out the ideas in this paper. Like, I think that these conceptually stand. I don't know.
We can go through it and then like I may reconsider. But it was just striking to me reading through it the first time.
I think that criticism is actually probably fair for half of the problems. Okay, but let's get into it.
Let's get in.
Okay, I would summarize this paper as saying, basically, the author is pointing out a problem with sort of alienation or isolation or depersonalization within what I have to assume is common between Scandinavian and British and US criminal justice systems. And pointing out that those issues leads Nils to put forth this kind of revolutionary idea as conflicts as property. And using that, the term restorative justice isn't ever used in this paper, but people, I don't know who actually coined that, but there's been sort of a large and burgeoning movement of this where people have used that idea of concepts as property to redefine and kind of recreate aspects of the criminal justice system, specifically for sentencing and sort of conflict mitigation.
Yeah, not just in practice as well. Like
one of
the supplementals you sent specified like a Colorado kind of policy implemented.
Yeah. So the
basic... and also like with regard to like the depersonalization and the isolation, I think the author also identifies conflict as an especially personalized experience where, and by kind of like removing that from society and from just general behavior, we're further kind of depersonalizing society. So so that's kind of what's going on there. Yeah.
And I guess I think it would do people a lot of good if it's like a 4-minute video. It's the shorter one that I linked to. If people could just watch that first, that'll give you a really good idea of where this theory has kind of ended up in practice, because that video is a couple years old. It was like the animated one that I sent you guys. I don't remember what organization made it, but that's kind of where this has ended up, where it's basically become instantiated as a practice of victims and their offenders kind of getting together within a very kind of, restricted and confined situation. Like, this isn't just, you meet at like a coffee shop or something, and they determine, through kind of exchanges of reactive attitudes, how best to resolve what the victim or what the offender did to the victim, and kind of how they can right that wrong in a more personalized way. I think that's kind of maybe the best way I can generally describe it.
And there's kind of like just an airing of grievances that need to be acknowledged by the perpetrator.
Yeah, the interpersonal connection was kind of key. Like, it was really one of the pillars, not just kind of like a secondary thing. Yeah, as is made evident by kind of like one of the introduction and
a big
examples.
And a big thrust of the paper and where it's developed into practice is supposed to be returning conflict resolution to the more organic way it always had been done, kind of pre-Enlightenment-ish. So, okay, I guess we'll kind of move through the paper a little bit systematically. I mean, we can just feel free to jump around with whatever, but so I thought, I don't know, I might skip. I mean, he kind of starts off with that Tanzania example of there was like this conflict in a very hunter-gatherer society, and he thought that it was interesting that 5 elements of the conflict resolution were present. Did you guys find those interesting, worthwhile to talk about?
I found them completely confusing when I first got there. I was like, where on earth is this going? His first sentence is like so controversial and like confusing. Then he goes into like a narrative, which I didn't find very informative. He seems to use like narrative devices a lot, which I'm not a huge fan of. But this example, like, I don't know that he even uses that to structure kind of his like theory. It's kind of like he observes 5 things and then kind of drops that.
Yeah, I actually found it like a very poor example, to be honest, because the thing is like because the thing is, I think he's trying to make this point explicitly for criminal cases, right?
Which is the hardest case. Yeah,
that's the hard case, exactly. But this is a civil case. even in the United States. Like, so, you know what I mean? Like this, the Tanzania example where, there's a man and a woman, and the woman,
it's just a divorce essentially.
Yeah. Well, they've been engaged, and he invested a lot of money, but she wants to break the engagement. How do they, kind of rectify the situation and return payments to the man who invested in the relationship?
Yeah, it seems to be not just expenses, but kind of some sort of like community acceptance, which I think is important for like the later paper.
Yeah.
That he kind of explains, but that's basically it. Like the 5 points are not structured to like methodically take it down in like the next section. It's just kind of like an example and observations.
I will say this is a point very kind of amenable to what you were saying earlier, Giffen. I did honestly find that there were some portions of this which were almost disconnected from what I took the central thesis to be. Like there were some sections of paper where I was like, I'm failing to see how this connects, like especially well.
Yeah.
And this was one of them. So let's just move past it.
Yeah, of course. We can get to the ideas if the structure isn't the the most important pieces.
Yeah. Okay. So on page 3 of the PDF, so this is kind of the beginning of the core of what he's talking about. So he says, courts are not central elements in the daily life of our citizens, but peripheral in 4 major ways. So the first is that the first and second I didn't get at all. For the first is that they are situated in the administrative centers of towns outside the territories of ordinary people. And the second is within these centers, they are often centralized within 1 or 2 large buildings of considerable complexity. And he talks about how like even lawyers can lose their way.
These were absurd to me at first.
I really failed to see how that mattered at all.
The first one seems to be...
The first one seems to be good. The first one seems to be like a fair point, considering, I mean... We don't have to go into, we don't, well, hang on, let me make my point here. But so like, I mean, think about sort of infamous cases that even have happened in our town, right? What if the trial took place in our town, right? I mean, you might actually be inclined to go. There might be more communal participation in an event that occurred in our town. So if the thesis here is to kind of further the idea of not just a victim-focused sense of justice, but more of like a communal sense of justice, then proximity does matter, I think.
That's true. I'm just kind of realized as you said that in fact, we actually kind of view the proximity as a bad thing explicitly. I mean, in some of the major cases that we've seen recently in the US, they had to go outside of the county to even find like a court that wasn't heavily biased. Well, maybe not outside the county, outside the town, because everyone was so like aware of the case and had pre-existing like opinions and knew people that they had to find like an unbiased jury selection elsewhere.
So that was the constructed jury, but for people to just witness the event, though, I think I understand the point being made here.
No, I think that's fair. It just kind of like came to me as you said that. I think that's fair enough, but it seems to me like the first point it might be a relic of Norway at the time. I don't know how rural it was, but outside the territories of ordinary people didn't ring as true to me.
Actually, the point that Adam made is making me think that it's important to emphasize again, everything that we're talking about here is for the sentencing and the resolution portions. It's not, none of this has anything to do with determining whether the person is causally responsible or culpable for the crime.
That is true.
Because I think that is like a really, I don't know what's kind of holding restorative justice back, but I have to think that people being confused about what exactly it's supposed to replace is a big issue.
That's true. He mentioned later kind of like what he's addressing isn't just purely to met out guilt,
Yes.
So I think that is a good point to make.
And it's very loose, the structure here, but like kind of based on the things we touched on earlier, where it's about sort of eliminating the depersonalization.
Yeah,
I think proximity in this case here is a factor in that, to point out, you know what I mean? So whether you agree with that or not, so whether you agree with that or not, and you're like, actually, I in fact don't think we should have that. Well, then you disagree with the thesis. You know what I mean? Of kind of eliminating some of those barriers to.
But it is worth, it's not arbitrary to mention that as the first point. You're right.
Yeah, I think it's a fair.
Mm-hmm.
So,
Okay. So I'm reading that point now as this is sort of a necessary. It seems to be an instrumental good. Like it's good in that it allows for more community engagement, and that's the thing that we're trying to reach more.
yes.
Right.
Yes.
Okay.
And I even see that with part two here, where, I mean, just to kind of summarize part two, there's a certain austerity to our courthouses currently. And I mean, there's a lot of truth in that, to the point where, honestly, it's quite scary, actually. I've been to the courthouse here in Pittsburgh several times.
I just went to dispute a parking ticket not that long ago.
It's kind of scary to walk into some of those rooms. And if you've never been, if you're unfamiliar with court proceedings, walking into a courtroom.
I was totally like jarred.
Yes.
Yeah.
Yes. So it's austere. I mean, there's no other word to describe it. So so there's a certain environment that doesn't really contribute to a community oriented kind of system of justice here. So that is a point to bring up.
And that's directly speaking to the third element that Christie addresses. He says this impression is strengthened when you enter the courtroom itself, if you are lucky enough to find your way to it. Here again, the periphery of the parties is the striking observation. The parties are represented, and it is these representatives and the judges and the judge or judges who express the little activity that is activated within these rooms. So it's like he's pointing to the fact that it's done by other people. The actual, offenders and victims aren't necessarily really involved in it. So, and I guess that directly leads to the fourth way in which it's not a central element of daily life. And he says, I have not yet made any distinction between civil and criminal conflicts, but it was not by chance that the Tanzanian case was a civil one. Full participation in your own conflict presupposes elements of civil law. So I take it by this, I wish he was more explicit, but he's also saying like pirating. Like pirating wouldn't fall into this because there's not like a victim there, right? Or like my parking ticket example. Like there's no victim to that offense, right? It was just like, so he's kind of narrowing the range of cases that this is applicable to, right?
Yeah,
he touches on the criminals in the rest of the paragraph.
Well, yeah, I'm saying there needs to be both a criminal and a victim. I take it as his point here.
Yeah, but even that's not made too clear, because it's like I have not yet made the distinction between civil and criminal conflicts. But it was not by chance that the Tanzania case was a civil one. I mean,
I thought the next sentence was the one because he says full participation in your own conflict presupposes elements of civil law. I take it that elements of civil law mean that there has to be a offender and a victim.
Read the next sentence.
But you could have in criminal law, right? Like a perpetrator and a victim as well.
No, I know.
But yeah. I think it's the full participation aspect there, which is like in criminal law, you don't have that because in civil law, at least here, like in the US, you've got like the plaintiff and the defendant, and the state is not, like a party in the case. So unlike criminal law where
it's someone versus the state.
Yeah. So I think he's basically laying out here is the fact that he dislikes the fact that we have to some degree, a separate kind of system in which we've kind of taken away the relevant parties and the state has kind of taken its place.
Yeah.
He says the Tanzanian case was a civil one to highlight the fact that that's kind of like the system in which he sees conflict resolution as being preferred is one which more closely resembles what we would call civil law. So it's like more of that system. He doesn't really.
Hey, let me read another quote. He says, so in a modern criminal trial, two important things have happened. First, the parties are being represented. Secondly, the one party that is represented by the state, namely the victim, is so thoroughly represented that he or she for most of the proceedings is pushed completely out of the arena, reduced to the triggerer off of the whole thing. So, okay, that aligns with what we were saying, because he's lamenting the fact that it is we'll get into this, but that the conflict has been sort of stolen from the individuals actually involved with it, and that it's been outsourced to either the state directly or representatives of the state.
Yeah. And once again, it's honestly, it's very, very convoluted here, because the thing is, like, that line still doesn't make any sense. Full participation in your own conflict presupposes elements of civil law. Yes, in Western countries, but you chose a case from an African country.
Yeah.
You could have possibly chosen a case that had elements of civil law in a criminal case in a different country. There are definitely countries in which criminal cases are treated like civil cases, where you have two parties that, I mean, like, that's a huge element of like Islamic law, right? Where it's like the state isn't involved in a lot of jurisdictions where you've got two parties that meet in front of a judge. And so I don't know why an example like that wasn't chosen, right?
Well, I think he's specifically critiquing like the Western system here. And he's bringing up, the fact that participation in your own conflict presupposes elements of civil law is kind of like, we already kind of accept these facts that I enjoy in one aspect of like law, but not other.
I thought
he's bringing up the critique here of those specific things, right?
I understand what you're saying, but I don't think the point was made here well.
Oh no, certainly not.
Yeah, because the thing is, like, he very well could have chosen a case in a Western democracy that was a civil case, and then said the exact same line: full participation in your own conflict presupposes elements of civil law. He didn't need to go to like the Tanzania example, except for the fact that there was more of a communal aspect to it. Like,
it was almost like trying to get us to invoke our like roots or something, right? Again, it was like kind of narrative pre-industrialization, I think, was trying to be invoked here.
Okay, so I think another weakness of the paper is that and I think it might honestly be a weakness of restorative justice, from what I understand about the larger practice, which is, again, it's not much, but he definitely could have been more clear, and he doesn't do himself any favors with talking about because I think that he raises problems that restorative justice doesn't solve, and it has kind of no business solving. So on the next page, he talks about in the top of page 4, he talks about how there's a less honorable temptation for the state or the emperor or whoever's in power to use criminal cases for personal gain and to like over punish people. But that to me seems like that would be an issue with the immorality of the laws more than the legal practices. Right. I take it that restorative justice, it can't really address. So like one thing that restorative justice can't connect with is the immorality of something like, the criminalization of marijuana, right? Like that's an issue with immoral laws. And I think that bringing up kind of either immoral laws or ways in which those laws can be bent by people in power is not necessarily the best way to make your case for restorative justice. Because like he's not trying to advocate that, he's not even really trying to advocate that power gets pulled from the state. I mean, there's a little bit of that, but it seems like he's more trying to advocate that I don't know, it's kind of like the acting out of all of that gets put back to the people. I don't know. Do you know? It's a minor point, but you got to be sharper, I think.
No, I totally agree. I totally understand the conflation you're pointing out there being made, where it's kind of like, it's less of a critique of kind of like the depersonalization and more of like the potential laws that could be used.
Yeah.
And then also like in this same section, another critique, to be honest, is
brutal.
When you read through this, like this is my third time.
I agree.
And it's like, and it just becomes more and more evident, like the issues with it. But also, didn't you get the sense in this section here that this is like just a massive straw man for why we have sort of this depersonalization.
He goes hard at lawyers in the next.
I thought it was hilarious. I literally
but-
made notes about what you guys might say.
Yeah, but it's like okay. As we all know, there are many honorable as well as dishonorable reasons behind this development, and this development being just the fact that participants in the conflict have been sort of sidelined
by experts.
Yeah. And they said, okay, the honorable ones have to do with the state's need for conflict reduction and certainly also its wishes for the protection of the victim. Those aren't the only reasons.
Yeah.
Those aren't the only reasons. Oftentimes, I mean, here's another one. Like, what about the one being accused is entitled to have the best defense available to them?
I was going to say fairness. Yeah.
Yeah, because like, what if you're just not someone who's good at making your own case?
Yeah.
Like even before, like even in front of your peers, like what if you just aren't well versed, but you didn't do it? Right? You are still entitled to someone who can speak on your behalf, you know, to make that case, even if you are marginalized in the process. So you could disagree with that and say, in fact, you know, a more personal system is, you know, preferential or preferred, I mean. But that is a reason why we have this, right?
Yeah, no, you're right. Like there are just huge like reasons that we have the system we have. And he kind of like in one sentence addresses like, well, these are good reasons. And then he just kind of just like passes it on. It's like, you didn't really give us a really full like exploration of the system, like the whys and like what we can kind of cut off that are just kind of brought along just because it's of like the development path that we had taken. And like nothing like that. It was just like, there are two good things. It is rather obvious. So is also the less honorable temptation. And then he kind of goes on after that. It's like he kind of missed something there.
Yeah, I mean, again, like imagine like you had been like falsely accused of like rape or something like that, right?
Okay.
And now you're gonna have to like almost address the community at large. Like there's gonna be you're not just addressing like the accuser, but you're addressing the community as they all sort of like watch on, you know. And in our system, you're not required to testify. You're not required to get on the stand. You're not required to provide testimony that could incriminate you if you feel like that you otherwise like you could take the stand if you wanted to.
Yeah. Wait, just to be fair, doesn't all of this have to be about the sentencing, right? Because what you're talking about is like providing evidence for or against yourself, but that's not necessarily in the scope. And if he's conflating that, then that's his problem.
No, but the idea here is that
but that you shouldn't have to represent yourself.
Exactly, because the thing is, like, in this system, you have to address your accuser, right?
Well, I don't know about that.
So here's the thing: in this system, you are supposed to address your accuser, but from what I mean, unless I'm conflating like the videos that Jordan provided with the paper, I think the restorative justice approach is supposed to be an option. Which should take the burden of a lot of these cases that we currently have in our current system. But presumably, you know, I mean, it's not really addressed too much, but there would be some analogous or simply the same system as the alternative option in those cases which you describe, where clearly you don't want to be just kind of put in front of your peers, you know, for
minutes after the sentencing. Yeah.
But I think, I mean,
well, so can I just to Giffin's question?
Okay.
Well, I just wanted to say in the current instantiation of restorative justice, they actually go out of their way to be extremely clear. I do know this, that everything is an option to participate in it. Because you could rightly say, like, you know, you wouldn't want to force, I mean, think of like, you know, a victim of sexual assault. Like, it'd be extremely immoral to force that person to confront their accuser if they were, you know, timid, or
period. You don't even need another reason.
Well, if it would just like re-traumatize them, like you could just really imagine that. So they but I don't know. I don't think that Christie says that you would have to. I think that he might phrase it in terms of like it is a pull.
Let me read this section then toward the end, okay, to sort of kind of
what page toward the end.
Then. Yeah, let me find this here real fast. Okay.
From what I read, Christie is saying is like it's an intrinsically powerful reason to opt for it, but I don't know that he was making the case that it should be required.
Let me read this paragraph on page 9.
Okay.
It would be the second paragraph.
I have this highlighted, yeah.
So let me add that I think we should do it quite independently of his wishes. It is not health control we are discussing, it is crime control. If criminals are shocked by the initial thought of close confrontation with the victim, preferably a confrontation in the very local neighborhood of one of the parties, what then? I know from recent conversations on these matters that most people sentenced are shocked. After all, they prefer distance from the victim, from neighbors, from listeners, and maybe also from their own court case through the vocabulary and the behavioral science experts who might happen to be present. They are perfectly willing to give away their property right to the conflict. So the question is more, are we willing to let them give it away? Are we willing to give them this easy way out? So I don't know. I think it's clarified in the next paragraph here, but
yeah,
I definitely got the idea that Christie doesn't think so.
Well, that is interestingly from the perspective of discussing the criminals, not the victims. So he might.
Well, but that's what I was talking about, though, right?
Yeah, I'm just thinking.
Because the idea is like if Giffen was accused,
mm-hmm.
they might say, okay, well, does Giffen have the option of opting out?
Well, actually, this seems to be after the sentencing, like after the guilt is established. So this is no longer a case.
Well, that's what Adam's saying. Do you have? So would Christie want you to have the option, Giffen? You've been found guilty.
Okay,
right?
Yeah. Once I've been found guilty, sure.
Because remember, all of this is happening after the verdict.
Right.
Adam's saying it's not clear that Christie would want. It seems pretty obvious, or at least it should be. Like I hope Christie would agree that, and the movement currently does that. The victim obviously has a say in whether they want to confront you. But
right.
From what Adam just read, it seems like Christie is kind of prima facie against the perpetrator being able to refuse the restorative justice.
I see. Yeah.
I don't know that you could convict him of that based on that alone, but he certainly
he wouldn't be upset with that result.
Clarity is not exactly a strong suit of this paper. I think it's safe to say.
That is a good thing to bring up, Adam. I appreciate you going to that.
That's interesting. And while we're on this, I have extremely the opposite view of the next paragraph where he says, let me be quite explicit on one point. I am not suggesting these ideas out of any particular interest in the treatment or improvement of criminals. I am not basing my reasoning on a belief that a more personalized meeting between offender and victim would lead to would lead to reduced recidivism. Maybe it would. I think it would. I actually think that should be a massive consideration of whether we do it. And part of, like I said, I have mixed feelings about this. One of the strongest pulls in the positive direction for me is that where this has been implemented, they've seen in Colorado, the one of the videos we watched, the lady giving the talk said that it was 90-something% participant, victim and offender satisfaction in the process, and that recidivism rates dropped because of that. And like, if that's not I strongly disagree with Christie's, like, this is not for their rehabilitation. Like, what? I actually think that should be a huge motivator.
Yeah. I mean, he even says like
if this practice was ratcheting up recidivism rates, if people were like reoffending,
that's
not even victims, but those victims, I would be shut it down. Shut it down.
He says, however, I would have suggested these arrangements even if it was absolutely certain they had no effects on recidivism, maybe even if they had a negative effect. He says that like later on in that same paragraph. There was another quote where I was like, what like informs your decision making here? It's at the very end. He says we might as well react to crime according to what closely involved parties find is just and in accordance with general values in society. I'm like, okay, we might as well, even it would, increase recidivism. I'm like, really?
There is very much a strain of deserve going through all of this, which I really disagree with, even though I do have positive views of the practice. I don't know. Point of huge. Oh, okay. You know what I? Okay,
Can I actually ask one clarifying question?
Yeah.
Where exactly in the reading here? I must have kind of missed this piece. Where exactly in the reading do we know that this for sure happens after the decision has already been made?
So I was looking at page 9, and then kind of in that paragraph that we were looking at, it says quite independently of wishes. This is the one you brought up. Kind of later on, it says like, I know from recent conversations on these matters that most people sentenced are shocked. So that kind of is one of the main points brought up in this kind of conversation about whether criminals should have a say.
I don't think that indicates. I know from recent conversations on these matters that most people sentenced are shocked. I don't think that's necessarily indicating that this happens after the sentencing, though.
Perhaps not.
It's not how I read that.
I kind of did for me, but again, I'm not gonna. We need to pull this guy out of. Actually, I think he passed away, but we need to really.
What I think we should do is go through the paper under the assumption that he does mean after the sentencing, because A, the current restorative justice movement does, but B, I think the only fruitful parts of this are going to come from after the sentencing. Like we can't, you know what I mean? Like I think that this idea gets way worse when it comes before the sentencing, when we're determining guilt.
Determining just the facts of the matter.
No experts, no lawyers, just hash it out.
Oh,
like
that.
But doesn't that seem to be sort of like the case though? Because okay, maybe I just read this incorrectly. Because let me give a point to another point here. I mean, I don't have to go to like specific lines, but there's a section here where he talks about introducing evidence that the participants themselves find relevant. Right, things like hearsay and just other forms of testimony.
Can you find this?
So I know that. Well, this is not the exact point, but this is in the same vein. He also says on the top of page 5, another is concentrated attention given to those attributes in the criminal's background, which the healer is particularly trained to handle. This is a very Straussian point. Like he says. Biological defects are perfect, so also are personality defects when they're established far enough back in time. And he's saying that he should, or rather, we should. This I thought was almost an incoherent point by him, because he's saying like, these are bad things to include in the sentencing because they take away from the attention given to the victim, but presumably in these reactive exchanges. And this came out in the videos, like those things would come up, right? It's like, so I thought that was an almost incoherent point by him. He's saying like we should not focus on the particulars of the offender, like, you know, whether he was biological defects, whether he had schizophrenia or something, right? But what if like that seems like it would be a central feature of, you know, like I'm so sorry I did this to you. My doctor had a stroke and I was unable to get my prescription refilled or something. But like, right, and this like, you know, what I did to you happened while I didn't have my bipolar medication or something, right? Like that seems like an obviously relevant detail.
Yeah. I don't know. I read this entirely different than you guys. I mean, what about the section where it's like we could potentially do it with judges?
Wait, where
you find this? The
hard part is sometimes wait.
Where is this?
Okay. I mean, like, okay, I have to at least find that one.
Maybe I
go ahead and find it.
I think I'm sort of think I read this right here because that line alone there where it's
well, I might plead for my. Let's look at this as after the sentencing, because before this is madness if this is all happening before.
Okay. So what this section on page 11 here?
Page 11. Okay.
Yes, sir.
So halfway through the page. So the idea is clear. It ought to be a court of equals representing themselves. when they are able to find a solution between themselves, no judges are needed. When they are not, the judges ought to also be their equals. Maybe the judge would be the easiest to replace. If we made a serious attempt to bring our present courts nearer to this model of lay orientation, we have lay judges already in principle, but that is a far cry from reality. Is what we have, blah, 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 blah. And then, should lawyers be admitted to court? Ultimately, the answer is no, there is. Well, so I don't think that this is like an after the fact idea. This is like lay people acting as judges, and there's some sort of mediator that is a lay person, and people can provide evidence. There's a section, like I said, where people can provide evidence that they find relevant. There is essentially a gallery of their peers witnessing this in a neighborhood of which the act occurred. That's how I'm reading this.
If he thinks that all of this is a prescription that he's talking about during the verdict discussion, no, not.
The lay judges.
This is one of the worst ideas I've ever heard. If that's what he's talking about, I was reading it through my lens of knowing how the practice is instantiated today. So this is all after the sentencing. He is gravely unclear at best.
No, I agree. He's unclear. Honestly, like I had no pre-knowledge like Jordan had, but I also didn't read it the way Adam did. Honestly, in this section, like the lay-oriented court, I was distracted just by the boldness of some of these claims. Like the specialization in conflict resolution is the major enemy. That alone is such a bold
big X. Yes,
I actually made a note because so Adam Smith in The Wealth of Nations, that is like one of the main points that he brings up is like the division of labor and specialization is what drives like in progress. And this guy is just like specialization is the enemy.
Well, but to be fair,
in the context of this, the point's a little bit different though. But the thing is, you guys agree with me now though. It's titled a lay-oriented court where you replace the judge.
Here's what I'll say. All of what you read is compatible with both versions, the reasonable and the insane version.
How is it compatible? How you're replacing the judge?
Well, if you're talking about if you're talking about in sentencing where the two parties reach a resolution that remember, so there was I don't remember where this was, but he said if two parties reached a conclusion, but the conclusion didn't meet some sort of pre-established threshold of punishment, then the judge would add on additional punishment. So I think that could be read. Okay, imagine this. Imagine that he says after the verdict has been reached, comma, and then says all of this. Do you know what I mean? Because judges are obviously involved in like the sentencing. So because right, like I think this is going to be a short episode. Like this is madness if this happens before. I think we can all agree on that, right?
I think it definitely happens before here. I mean,
no, but what I'm saying is it for the fruitful version of this, which is the current day version, it only happens after the fact, which then I think there are still huge problems, but it becomes a more interesting discussion.
Yeah.
Right. So I'm just saying, let's provide like a big bracket as if he were more clear about this being after.
I'm just saying. I mean, the whole point of the paper is that our current court system, it's like
I know. The language is loose as a goose.
It's very hard to find the author's voice versus like the author presenting something he doesn't like. It is like critiquing that, versus just a kind of like just a straight observation that was kind of like pen to paper wrote and then never critiqued whether or not it should be included.
Pen to paper. Can I circle back and say I wanted to say, because so far we have focused on the parts that we don't like. One part that I really liked is his diagnosis of a lot of the issues, and I was actually not really a page. Well, I guess it kind of happens towards 5. It's like between 4, 5, and 6. I mean, this was more of a general point.
Oh, okay. Please continue.
I really liked his diagnosis of. I think you guys would agree with this, but it seems like I mean, this is all the more true in 2021 than it was in like 1977 or whatever. But haven't you guys noticed there's an increasing impulse to immediately take issues to a higher authority rather than work them out yourselves? And I think that this happens like, I was kind of thinking about this. If you think about a spectrum of interpersonal disputes within an organization, say a university or uh, an employer or a nonprofit, just an organization. Then in the middle, you have civil cases. And then at the far end, you have criminal cases. I think that the idea of conflicts as property is the most germane and most beneficial in the interpersonal cases of an organization or in a university or something. And it needs the least amount of, or the lowest amount of supports, scaffolding, bracketing, that kind of stuff. And those two things reverse as you go to a criminal case. So I think that this becomes more and more problematic as you get to a criminal case. But think about like, Adam, do you remember we were discussing, Brian and I were really discussing a lot of the issues that we had with the resident assistant roles at Pitt?
Yeah.
We were talking about that.
Yeah.
One of our biggest issues is that the entire way that conflicts are resolved in the university housing system is extremely infantilizing and dehumanizing in the way that Christie points out. Because like when we were being trained to be an RA, there was encouragement, to say the least, to immediately, every little thing just got escalated to like higher levels immediately. There was no emphasis put on actually like restorative justice. There was no emphasis put on people owning the conflicts as their property. It was actually like when I looked at it through that lens, I thought that this was really interesting. And like also, I don't know, think about it. I haven't talked like a whole lot about this book with you guys, but Jonathan Haidt and Greg Lukianoff have that kind of recent book, The Coddling of the American Mind. Mm-hmm. And it's like a really balanced and measured book. And one of the things they talk about is this impulse to like everything is immediately like just report, right? Like if there's like a conflict, like there's a microaggression or whatever, you just immediately report someone. You don't actually like talk to the person and express how this made them feel. And this was, remember, he talked about one of the benefits of this is the reaffirming of norms. I think that this, if you give me this and say this is how university disputes should be looked at, or or issues within your work or your employment, or like I begin to love this idea. What do you guys think about it through that lens?
Yeah, I mean, it makes sense to me. I think it still works within civil procedure. So if you have some complaints about a coworker or just someone within the organization that you described, then yeah, I mean, it should be handled between those people. It shouldn't be brought to an authority where there's like this entire depersonalized kind of court in session to kind of mete out punishment. So yeah, that makes sense.
And I agree with Jordan. Like the observation does seem to be true that it's kind of like the instinctual reaction, right? It's not like, well, I made several measures in order to like reach out to that person and try to explain my case. It's like, well, there was a conflict and this body is the one who should, resolve the conflict.
Have you guys ever reported someone like that in your life? I never have. I have no impulse towards that thing.
No.
Like, obviously, if someone committed a crime, that's a different issue. But like
I've never,
I've witnessed many a crime, never reported a one. No, but like, I don't know. I actually do like kind of viewing this through that lens of like, I actually do kind of think we're really weakening people's abilities to resolve conflict as their own property.
Yeah, no, I agree with that.
Like when we were, I don't know, like when we were like, growing up in school, it was like, it was very dishonorable to kind of take a dispute to like the teacher. The
invocation of honor there is
like it is extremely dishonorable. Right?
he comments on honors explicitly somewhere. I don't remember exactly where.
It's so funny because it's so true.
Isn't it the perfect?
You're like the biggest rat in the world. Like, took it to like it's like I've learned the principle of this behavior. Like, oh my goodness.
Like it betrays like a weakness, really, like an interpersonal weakness. And the thing is that when you outsource all of it, it doesn't, it's like a muscle. You have to actually exercise it to improve.
Atrophy is the result, naturally.
So like, I thought that he was pretty astute at diagnosing a lot of the problems.
Did you guys look into the application of restorative justice with regard to the Rwandan genocide?
No.
Okay, so I looked into that. So the little background with that, I'll kind of keep it a little bit vague, just because some of the terminology I don't know as well. But pretty much, like the population is like around 10 million, and 1.2 million of the people were involved in the genocide, either carrying it out or like were accomplices, right? So it just wasn't feasible.
You can't jail a tenth of the population. Yeah.
You can't.
Yeah.
So as a result of that, they kind of like implemented like thousands.
I have heard of this a little bit, actually.
Yeah, like thousands of courts where there were obviously
weren't they called truth and reconciliation courts?
They actually had like a very kind of like specific native name, actually.
Oh, okay. Yeah.
Yeah, specific. And so I don't remember the name, but either way, they did mete out punishment, so there was sort of like a retributive justice involved there, but there was also just a huge element of restorative justice where they got individuals together, honestly, and allowed victims to air grievances to these perpetrators in a community setting. And kind of that was a big part of the justice there, because you can't jail a tenth of the population.
Yeah.
So yeah, I thought that was pretty interesting.
That is very interesting.
Correct me if I'm wrong. Well, I didn't get a lot of this from the paper, but it seems congruent with the paper. Well, I guess it was in the paper a little bit. It seems like also, so the restorative justice obviously includes punishments for civil and criminal crimes, but what it does, I have a lot of mixed feelings about this, because there's obviously there's an obvious good in allowing the restitution to be personalized, right? Because if the same crime was committed to two different people by two different people, the way that crime would be perfectly restored, or that person's life would be restored, is going to look different, obviously, right? Because like if Adam has an iPad and I have an iPad, and Adam's just has, Netflix and porn on it. It's just
those two things.
just those two things. Yeah, Adam's iPad is for pure, it's just a filthy place. But mine, I use it as my work computer, right? Like I have an extendable keyboard for it and everything. It's a way different deal if both of those iPads are stolen, right? Because Adams has to log.
It's a much bigger deal for me. Yeah. Yeah.
The restoration process is going to be lengthy.
Yeah,
Adam's restorative justice is going to be refilming all of those.
Oh my god!
We have reached an impasse. Adam says, "Can I just pay for the iPad?" No.
Send it to the judge.
I can only be restored with your execution.
So, for I take it that I don't know, it. So the way in which restorative justice allows you to personalize the restitution seems to be a good thing, right? But here's where I'm worried. I guess the concern that hasn't been addressed at all by this paper, and actually at all by the videos, is bias, I guess you would call it. So, like, I take it that a strength of our criminal justice system, at least in theory, if not in practice, because I know in practice it doesn't work, right? But like, it's supposed to be completely impartial. So your race, for instance, should not, in theory, because it probably does in practice, but your race shouldn't factor into your sentencing from a judge in our current system, right? But what if, like, what if you're a black person and you commit a crime against a white person, and that white person happens to be, like, not even just implicitly but explicitly racist, right? And they're like, no, this person should, they're just going way outside the limit of what's reasonable.
Yeah.
So, because so the way that the current system is formatted today is, I think that there are minimums and maximums for different crimes, right? But what happens is, within those mins and maxes, the conversation between the victim and the perpetrator can attenuate that to a degree. So, for instance, if it was theft, right? this was an example in the video. If your iPad was stolen, and the criminal can do a lot of work to try to get it back, that might be a reason to reduce the sentencing a little bit, right? But what if the victim was extremely racist, and they got their iPad back, and then they're like, the maximum time, this person, like, I'm not going to be happy unless this person gets the maximum time.
Would that happen after?
Well, because it's not clear that it's not.
I thought the restoration itself was kind of like, in some ways, replacing the sentencing itself.
I think it's supposed to supplement it. I don't think it's. I think that would be even a worse problem.
Well, not okay. Yeah, I don't mean like there would be no, but rather it ought to, in many cases, replace at least some of, or the majority of.
I guess that's what I was kind of saying, right? Is like, what if, like, you know what I mean?
Meaning both would be determined congruently, as opposed to, like, the restoration happens and then, because I mean, in your case that you described, it's like, well, that is clearly flawed. I want you to, like, spend weeks getting my iPad back. Adam says, he's like, okay, well, I did it. Like, I hope we can put this aside. Adam's like, death penalty or bust. Like, what do you mean?
Or bust. Double entendre.
Adam's like, bust.
Oh no.
Death penalty or I'll choose the
latter. I mean, I think that's where also, like, the communal aspect comes in, where it's like, this isn't just like in isolation. This is in front of, like, a community, and there's also some form of mediator there as well.
Yeah.
So I think that all kind of comes into play in terms of the sentencing.
I think the problem with Christie's advocation, though, is that he wants it to all be local, non-experts. So you just get a racist town, and you'll have.
That's what I was thinking.
But also, he doesn't really
elaborate.
He doesn't elaborate on many of the things that we, even our first reactions, that would bring up. But, like, this would involve not within a community, but between communities, and that alone is kind of pulls at the concept. He mentions earlier some, like, generalized values. I'm like, you're not going to get very many generalized values between disparate communities.
Yeah.
And the whole thing, I mean, his outlook, I don't know his philosophy fully, but he seems to be, like, almost anarchist in his anti-statism.
He has an extreme anti-expert, like, thread going through this, which I
also
very disagree with.
There are several of those. But, like, the anti-statist one especially is, like, it seems incongruent with just any modern society, like the execution that he's referring to. He makes assumptions that seem to me from the beginning to be kind of, like, informed by growing up in, like, rural Norway. That kind of, like, bleeds through. It's like, as, like, kind of his perspective, and he even admits, like, I have very limited knowledge of the British court system and let alone the American system.
Don't ask me what side of the war I fought on.
These things like clearly break apart if you just imagine okay, imagine someone from California drives into one of the rural states in the US. What the concept of community here, it's kind of hard to parse. What are the representatives of these cases? The families perhaps are involved.
Giffen, that's actually a fantastic point there. Yeah, I mean, if you're not from the community, this is going to be in front of a community you're not a part of. I mean, there's no way that's going to be fair and balanced.
The worst. I mean, even if you have the situation in the Tanzania case where both parties are represented, it's who represents the California dude? Just 3 random Californians? It has to be family. And the worst part about it is I mean, you can debate whether this is actually good or bad, but I'm imagining if you kind of implement this in his view, you kind of have a tearing apart of the large kind of community, which is what we consider the United States, right? There's sub communities, of course, within there, but he just does not care at all about the state, it seems. And so you can just imagine that we would go from kind of a large, diverse nation with some shared values, down to just very, very small sub communities, in practice. And it seems to me that it pulls against our intuitions, I think. But he just doesn't have a care in the world for it.
There's a way in which I don't know, I'm kind of trying to, I don't really have this thought fully formed, but
yeah.
There's something that I don't like about, it's weird, right? Because, okay, look, if this restorative option or this restorative justice is an option that if both parties sign up for, they can participate in, and in doing so, it will naturally tend to reduce the sentences given based on both of the wishes of the victims and also sort of the judge's input based on the outcome of the resolution, right? Because you could imagine, you engage in a restorative process and the offender just spits in the face of the victim. I don't, okay, that's not going to be attenuated at all, obviously, right? Then there's another one in which after days of conversation and mitigation and apologies, right, they actually search for a way to right this wrong. And the victim and the offender both come up with a partial restitution. And then based off of that, the judge okays on, just in our system, this crime would have been a 15-year sentence. Now it goes down to 18 months or something based on these. So I'm assuming also you would probably fulfill the restitution and then serve the time, right? That would be the natural order in my mind.
I think that's up in the air. The actual,
the details aren't
between the people.
Out, yeah.
I mean, he doesn't really comment on it at all. See, what we need is the follow-up landmark paper to this concept.
Yeah,
the one with a similar number of citations, but coherent and addressing points that we would. Even our first intuitions come up, and it's just not addressed. Some papers,
there is
you think of things, and it the author predicts what you were going to say and addresses those points. This is the opposite.
Wolf is my number one example of that. Yeah. Okay, I know I have on my phone. Oh, I really hope that I saved it. There was one. It's a chapter of an edited volume. Here it is, chapter 8 of this Cambridge Core edited volume. Reactive attitudes and second personal addresses. This is supposed to be. I don't. Let me just read the introduction. Resenting a colleague's unfair treatment of you, feeling hurt by a lover's oversight or guilt about shirking an obligation, experiencing indignation of an official's abuse of office, contempt for another's. Okay, more examples. They are joined by a more attractive group of sentiments, attentive to the right and the good, pride and sacrifice one makes for another, gratitude for a favor granted, and certain forms of love. I don't know that this at all speaks to restorative justice. I heard a discussion of this in the context of restorative justice, but maybe I'll have to look into this if it actually directly discusses it. Because I'm not sure. But yeah, this would be interesting to like read a more recent follow up of this, because I don't know, what I was saying is that like if you tell me, if I believe the stats, which I do, that this results in more victim and offender satisfaction in the process, and it leads to reduced sentences, and it leads to reduced recidivism, I'm really on board for this being an option.
How can you not be? Like, even
Yes.
just like the 3-minute video from like the Colorado case, which it seems more of an advertisement, looks so promising. How can you not be for this? But
Yes.
like, this is another thing that I was talking about at the beginning about the expectation is you don't really get that sense from this paper.
No, and
I know it's a result of like years and years, like decades, in fact, of like kind of discussion on this and like the creation of this as a kind of subject itself. But nevertheless,
a lot of this in my mind actually just comes down to the empirical reality of just how this plays out, I think.
Yeah, which is frustrating because he seems to care little for it. It's the inherently good, whether it increases recidivism.
Yeah. He has a very sort of deontological view of this, which I very much disagree with.
Well, I think the analysis is based on the consequences, but more in a loose sense based on the effect it has on the victim or the victims.
Yes.
So more practical consequences such as reducing recidivism or just reducing sentence times, as you mentioned. More practical concerns be damned, and more focusing on just the effect it has on the psyche of the victims.
Yeah.
So
he's almost like presenting it should be a value. But
yeah,
because it seems like, I mean, to be frank, like the idea of the conflict as property was totally foreign to me. So it seems like he's pitching it a perspective entirely. But you're right. I wish he would kind of engage with some of the practicality.
You know what's interesting too is like I actually think that the norm clarification aspect of this is undervalued in the paper, because I'm just kind of thinking about it introspectively. And let's use like a non-legal example, right? So let's say like back to the university example, right? There's like some dispute or like, some offense was taken by something, right? Like the way it currently works, when you just escalate it, because normally, okay, so the person A offends person B, right? The way it works is person B just immediately, without person A even knowing this is happening, just reports the incident to someone, right? Then that person usually would probably end up reporting it to someone else too. And then it's kind of like that's the removal of the conflict as property.
That's the theft.
And then the sentencing just comes down and is applied to the offender. In a way in which there's actually no connection to what they did in the victim to the victim. It's like a it actually kind of resembles like the problem with religious punishment. It's like it's not wrong for me to wrong you because you're another individual. It's wrong for me to wrong you because God told me not to. Right? Like it almost has that same weird parallel going on where like I'm imagining also that the person given the sentence doesn't feel the same level of remorse. He probably hates that person for what they did, like reporting it up, right? Whereas if you were encouraged to, when it was reported, because okay, let's be clear. I don't think it's reasonable to assume this is like a cultural point. It would be better if people just defaulted to interpersonal exchanges, but like in a system in which that's not the default. When the offense gets reported and then this restorative practices is instantiated, I think that this would work out just so much better. And the victim would actually understand what was wrong. And I think in the current practice, it probably just re-intensifies their beliefs. I'm actually thinking now that this does more harm than good in at least interpersonal cases, if not also civil cases. Like the way our current report and then punish from above system is set up.
Yeah. No, I agree. It's a disaster. I mean,
it's really bad. It's really bad. It's
just infuriating. It's like it's almost like in this case, if we're using like the terminology of this paper, it's almost like conflict property theft by the victim.
Yeah,
They're like
yeah,
they're kind of the thief in that circumstance where it's like oh, this really should have just been between us. Like
yes,
why did you take this and pretty much give it away?
yeah.
So in this case, it's theft by the victim.
Well,
So
I think he would
I
probably
actually really
argue
like
it's.
that. Yeah.
I think he would probably argue it's theft by the institution, with whether it's the state or like the system set up in the university.
There's two thefts. There's the theft by the victim is the cultural reaction to just send it upstairs, and then it's reaffirmed by the people who accept it upstairs. You know what I mean?
Yeah, well, I think that I would guess that Nils's view would be that it's the institution that kind of bred the culture in which that's the case. I don't know for sure, but I would imagine that his invoking of like the Tanzania case was to say like this is what it ought be in the natural way of things, right?
Yeah.
Before the institutions were there.
yeah, but it's almost like if you and I like went 50-50 on like a TV,
Sure.
and then so we owned
And Adam just watches porn on it all day.
Oh my god!
Adam, please.
So I take that TV.
Okay.
And then I go and just give it and sell it off to a pawn shop.
Okay. Okay.
Like the pawn shop is like almost like complicit in the theft.
Yeah.
You know what I mean? Almost like in the same way the university is a participant by accepting the conflict in that case. But it's almost like to what degree is the pawn shop, culpable in the theft?
I think there's a little bit of a difference between the two cases.
I see the parallel.
I see the parallels, right? Yeah.
Right, because like the pawn shop, like even like their existence allows for the theft, right? Because otherwise, who are you going to be selling it off to?
And
right?
also on the university level, when they reaffirm the escalation of the offense and then just bring down a punishment, they are confirming, yes, we want to rob the offender of their chance to actually be a member of this resolution.
Oh, I don't disagree with that. What I was arguing is only that it's the institution itself, from what I can gather from Nils' view, that is the thief, not the victim.
No, but I think the way Adam,
I'm arguing for both.
Yeah, it's both. And I because okay, think about it this way, like I kind of like I wrong you in some serious but non-legal way, right, Giffen?
Sure.
And you then are presented with this opportunity or this kind of like this, there's this bifurcation of what you can do. You can just escalate it to some, say we're at the same university, you report it to the whatever department it would be, dean of students, right?
Yeah.
You, in doing that,
just dean of porn. He's wrong.
He never
disgusting.
Let me use the
I'll
TV.
allow it.
Yeah. Like the dean is back. Well, what was he watching?
It's actually the dean's like, this is actually outside of my scope. This is going right to the authorities, right to the Fed. So.
The dean's like, well, I'm interested in helping you two boys restore some justice.
Oh no.
I lost the track of the hypothetical a bit.
I wronged you, Giffen. and
right.
Okay, when you are faced with the choice to escalate it or not, when I wrong you, in that moment we're sharing in the property of the offense, right? Mm-hmm. It's both of ours, half and half, essentially, right?
Yeah.
When you escalate it, you steal my half. And it's almost like you're violating your own half of the conflict too. And you're just pushing it upstairs to say whatever ruling, because the thing that Christie points out that we actually haven't talked about is there's a real theft both by the victim, but also from the victim, right? I know, so in a discussion I listened to on restorative justice, also in our current US system, sentences that were given out actually were on average far higher than what people in a restorative context would have actually wanted to be done to the victim, or I'm sorry, to the perpetrator, which is really interesting. So there's this sense in which also like in our example, like you just get expelled or whatever. And I, as the victim, I'm like, whoa, I didn't want him to get expelled from the school. Like, but as soon as you kind of kick it upstairs, you're robbing yourself of that half too.
No, I see what you're saying now.
Yeah. Yeah. That's actually really interesting. I wonder if anyone, that'd be cool to see if anyone has like spun it in that direction as like, this is a better way to deal with university issues. Because it's actually agnostic as to what the right answer is. You could advocate on this purely in just pragmatic terms. You know what I mean?
Yeah.
Yeah.
I would hope in nearly half a century since the paper was published, there's a little bit of enlightened commentary on some of the practical So I think we should look for something that addresses some of the concerns of ours, or at least reinterprets the paper.
I know I was reading a book in defense of honor. I think that's the title of it. It's like a kind of a trade book, but it's pretty philosophically heavy, by Tamler Summers, actually.
Okay.
And in there, he has an entire chapter on restorative justice. So I could, and that came out a couple years ago, so it's pretty recent.
Yeah, that seems like a viable option.
Yeah, I could scan the pages and we could do that as an episode, maybe.
When I was reading this paper, here's like another area that kind of I was just reminded of. It's doesn't parallel perfectly, but when you got into that accident a few years ago,
dude, I had a note. I literally had a note about that. I was gonna bring it up.
Yeah. I right when I
oh my, that's
right when I was reading this, I thought of that exactly because
I thought of it too.
You like rear-ended someone because of like their poor driving, but
yes.
And then you were like, okay, like it's not a big deal. It's actually very small, and I can give you the money
for it.
Yes, it's a very, very small thing. But then that person took it right to the insurance company. It, obviously once the insurance company gets a hold of it, it's now thousands of dollars of damage.
Yes. So it was ridiculous. That is, I mean, that's a perfect example of where, now I don't know that like insurance is exactly the best.
Yeah.
Because that's like all intertwined with like legal, but that's like a perfect example of where the societal impulse should be, just to allow someone to pay for it there. I really do. This is like one of my most sort of like curmudgeon-y views, but I do think that like we really have encouraged kind of a weakness or a softness in society about that. Like
just a lack of trust too.
Yeah.
I mean, it's just like that person like just had like no trust in people.
Yeah. Like we really are extremely fractured as a society at this point.
Yeah. It's like very small damage. You're like, okay, I can pay you. You called that person like that night trying to get a hold of them. They wouldn't even answer like the phone.
Yes.
So it's like if I was in that position myself and somebody called me and said, okay, I want to pay for this immediately. Can we do that right now?
Yes.
Like it'd be like, okay, go see your whatever auto shop, get a quote. I'll pay for it.
Yeah.
Okay.
Yeah.
But no, they had zero trust. So
yeah, I'm curious to what extent this is informed by like kind of the highly industrialized society we live in. I'm just curious because that clearly informs the aspects of trust, and community size clearly has a big impact on the practicality. So I'm just curious if there's any literature that kind of addresses.
Christie made me think of another text I want to read in this series, Estranged Labor by Marx and Engels, because he talks about how, I thought that this was an interesting point too by Christie, because he talks about how we view people as their role in things, not as individuals. You view...
I liked that part too.
I liked that part, yeah. Like you view... This is like some weird dreamy-eyed view of like the past or whatever, but like I do feel like there was a sense in which even the difference between us when we were growing up, like I just feel like I was friends with my neighbors. You know what I mean? Like I just feel like that doesn't happen anymore. And I don't know, there's like a real kind of depersonalization in life itself. Which like Adam and you and I have talked ad nauseum about this, but like Giffen too. Like I know that we're extremely thankful to have grown up without cell phones for the most part, without like smartphones especially, but it was just like a much more organic, for lack of a better word, upbringing that was kind of restorative justice. Like it was like a Mad Max version of restorative justice. You know what I mean? Like wrongs were righted without authorities coming in unless they were the most like, really egregious cases.
Yeah.
I don't know. I don't, there's something that I love about this paper, but I also am just so hesitant about the way in which this could be done, Well,
you can really see that it's like an inchoate idea where it's just like, it's just the beginning of it. You can see some positive ideas coming from it.
Yeah.
But the idea itself in this first paper isn't that good. Even though you can see the potential for it.
Yes.
So,
an interesting.
One last point, sorry. But just kind of remarking off what Giffen said, I had never thought of a conflict as property either.
Oh, I had never before.
So like that whole framework is actually like, it adds a new interesting lens to kind of view this topic.
Yeah. It's insightful.
Yeah, but like that part you could have gotten from like a 2-liner on Wikipedia, that like he kind of, I don't know. That idea itself.
Give him a little more credit.
I mean, like the paper included more aspects than just conflict as property, but that aspect itself was presented kind of over several paragraphs, which included unnecessary sentences and intuitions.
Yeah. I could have gotten it from a TikTok.
The most famous.
Dude, I'm gonna just completely rearrange my life. So it's just like the TikTok series on conflict as property, just estranged labor, the TikTok version.
Conflict as property.
Show up to a conference where he's like giving this talk after it's over. Like, I could have gotten that from a TikTok.
Back in 1977, you remarked that
instead of presenting at a conference, you just play like a series of TikToks. Any questions?
One last serious thing, and then we could probably end this. This actually, I would have never thought of this idea. This is really piggybacking off of the previous series. There's a way in which this sounds extremely counterintuitive, but I think that this is exactly what restorative justice is doing. It's leveraging this. This sounds extremely implausible, but I think it actually happens. It leverages reactive attitudes in attenuating people's retributivist desires, which is it's really counterintuitive because you would naturally think that reactive attitudes would motivate the higher retribution, right? But I actually think that people, and I'm just really armchair hypothesizing here, but I think that the reduced sentencing and the reduced recidivism and the higher victim satisfaction comes from, like, I think it's really easy to hate someone when you have all of the sentencing removed from you, right? Like, you don't get to learn about the person. You don't get to understand like their own struggles, right? Like, and those are very reactive attitudes that you engage in. And even getting really mad, like could well imagine you shouting at the person, like being extremely angry, like how, but there's a weird way in which expressing those reactive attitudes seems to, from like the statistics we saw from the TEDx talk, attenuate people's retributivist impulses, which is really interesting. Like I wouldn't have thought about that in this way.
I think it does make sense. It's a great point on your part because I hadn't really thought about it, but it does make sense in the sense that, like, in the paper, Christie kind of points out that if there's this depersonalization, you can view the perpetrator as just non-human.
Yeah.
Like, but it becomes very clear they are a human being once you're interacting with them and expressing yourself, and they in turn express their, experiences that led them to, partake in whatever they did. So, but that does make sense.
Yeah. And I guess the part that you would really want to avoid the reactive attitudes in is the setting of the min and max. Like that's where you really do want to adopt the objective stance and just, like how does this benefit or harm society or this individual person? Yeah.
Yeah.
All right. Well, I
Giffen,
think
you were going to say one last thing, Giffen?
It has been lost.
I'm sorry. I'm sorry. I cut you off there.
And what he said could have been found on a Wikipedia article.
Nothing but a TikTok comment. It was fine.
All right. Well, I don't know what we're gonna do next, but whatever it is, I hope listeners found this enjoyable and informative, and tune in for the next one. Well, I hope you enjoyed that episode of Plato's Cave. I always enjoy discussing topics with these two guys. So if you want to support the show in any way, you can do so simply by sharing it. I'm hoping to get this show out to more people. And so if you want to share it on Twitter or social media, that would really help me. You can also rate it on Apple Podcasts. Like this video if you're watching on YouTube, or subscribe via Apple Podcasts or an RSS feed. You can also discuss it on your own show and link back to my website, or you can connect me with recommended guests or topics to cover. You can get in contact with me at platoscavepodcast@gmail.com. Follow me on Twitter at Jordan_C_Myers. And I now have a website for my philosophy endeavors at jordanmyers.org. If you want to know a little bit more about me and my fellow co-hosts, as I said in the introduction, I'm a master's student in philosophy at the University of Houston. I did my undergrad at the University of Pittsburgh, where I studied mechanical engineering and philosophy. And now that I'm back at school, I'm hoping to more closely study moral responsibility, free will, ethics, epistemology, and moral psychology. Those are topics that I was introduced to and got really interested in my undergrad work. So Adam and Giffen accompanied me on this show, and Adam is one of my oldest friends. We actually met in kindergarten, and we've been interested in philosophical topics for as long as we can remember, and in a lot of ways it's been the basis of our friendship. Adam studied chemistry and biology at Cornell, and he is currently working at a law firm. And he's especially interested in moral responsibility as well, but also law, religion, and free will. Giffen is also one of my oldest friends, and we've been friends since elementary school as well. Giffen studied biology and economics at RPI, and now he works in human health research. He believes that there's very interesting overlap between both of his fields of study and philosophy, and he's particularly interested in exploring political philosophy. So this series was right up his alley. And with all of that information, again, I hope that you enjoyed this episode, and I hope that you get in contact with me or follow my work in any way that you deem reasonable to do. So with that, thank you for listening.